I didn't have to hang around on the scene of this fatal accident until the police could show up and basically test to see whether or not I've been drinking, because in his reading of the statute, it just doesn't require that.
Correct. And what we've also seen is that the defense here has proposed some exhibits which will ultimately allow the prosecution 24 hours to review, and then they'll be able to rebut the argument. We do know that the 911 tape did come in, which you heard, and they also have some, they will also be looking into the legislative intent, which is something that we talked about here previously, right, Jonna?
Yes, it is. And you got to remember where we are right now. This is a pre-trial hearing. So for the purpose of stopping the prosecution of this case, if the judge sides with the defense here, and the defense is basically saying, look, we have a statute that, as applied to this defendant, commands that you dismiss this case against him because two reasons. Number one, he complied with everything he was legally and morally supposed to do under the interpretation of the statute. And number two, by the prosecution suggesting that he should have come back to the scene or waited there until the police arrived, you would be violating this defendant's constitutional rights to be free from his Fifth Amendment rights, essentially, to not have to be a witness against himself or testify against himself. Both of those arguments, I think, are successful. He's making a very cogent, good, strong argument here.
It raises interesting questions about whether or not this law was drafted to try to get around those constitutional hurdles, or whether or not it was drafted in conjunction with them, or basically if it needs to be redrafted.
See, I think what the defense attorney is smartly doing is he's giving a cue to the judge that says, look, I'm not asking you to rewrite the law. I'm not asking you to declare this entire statute unconstitutional as to all of the land. I am simply asking you, Judge, that when you apply this law to this defendant, it doesn't line up. And essentially what we have here, I'm going to call it, it's akin to a probable cause hearing, where when somebody has been arrested without probable cause, there is no point in continuing on to charge this person and prosecute them in front of a jury. The judge has the authority, upon motion, which what we have here, to stop it if it doesn't apply, and that's precisely what the defense counsel is saying.
Well,
here.
Jonna, let me ask you this question. So if the defense here is asking the judge to look at this particular issue with this particular defendant, what happens in the future? Will more defendants be able to claim the same thing if they follow the same exact steps that Chris Soules did here?
Sure, I would imagine you would have very similar arguments happening in the event that the prosecution wanted to continue on with the case. I mean, also remember where we are here. When you have somebody, forget that it's Chris Soules and he's on TV and he's got some level of celebrity. You have somebody who's charged with an offense. The prosecution and the defense get together very early on to determine what, if any, charges should stick. And when you can come to an agreement, you don't have to go forward with a hearing. You can come to an agreement. The prosecutor can dismiss a case, reduce charges, do whatever you'd like, whatever you can agree to. So we're here because the prosecution has dug in and said, no. And I think the defense attorney alluded to this, that the reason they're doing it is because they do think Chris Soules got away with something more that they will never be able to prove, i.e., perhaps drinking, and that might have contributed to this accident.
Well, do you think, with your legal expertise, do you think the defense here is maybe bolstering this insinuation by claiming perhaps if he had stayed at the scene, then his Fifth Amendment rights would have been violated?
Well, then that's the only way the argument makes sense, right? So in order to say if he had stayed or come back, his Fifth Amendment rights would have been violated, you almost are indicating that something was unlawfully going on there. So it can cut both ways, but I still think the defense wins that argument because they'll never be able to prove what, if anything, was going on in addition to simply having an accident.
Yeah, exactly. I mean, they don't have anything on him at this point because he went back to his house and then wouldn't open the door when the police showed up, made the police wait to get a warrant, which took a lot longer than they probably wished that it should have.
Right.
So they can turn around and say, oh yeah, he might have been drunk all they want. There's no evidence of it. So even if the state turns around and says, well, then they can't go after him for it.
And they'll never be able to prove it. And if we are here for the prosecution side of this hearing, I bet you that's exactly where they're going to hone in. They're going to try to get the judge to believe that there was more going on here, or the argument that his Fifth Amendment rights would have been violated wouldn't apply. And that's the very argument that the defense attorney is making. So that, And that may give the judge a run for her money here too. But I still think it's a very strong argument.
You know, here's the thing. The statute is got a lot of confusing what-ifs in
Oh,
it.
sure does.
Okay, and I'm trying to chart it all out here. If there's property damage in Iowa, there's just a requirement in the law that they exchange info. If it goes further, then they've got to stay on the scene. But it says that they can leave basically to seek necessary aid or report it. Well, if you report it by phone from the scene, does it necessarily work to flip over and say, well, you can then leave? I don't think that it at face value it justifies that reading.
So, and that's one of the questions that the judge is going to have to answer. They already have this in a tight little package, because the defense attorney basically said, listen to the 911 tape, which was only 6 minutes, that the prosecution said, no, just read the transcript. And I'm glad the defense attorney insisted on hearing it. Because in that span of 6 minutes in that call, we now know that he stopped immediately, he called immediately 911, he identified himself, he identified himself as the driver. Didn't have to do that, right? If you're not driving, you're not in any sort of criminal trouble. Stayed, rendered aid, or helped somebody render aid, and then he left the scene. And you got all of that in a 6-minute call.
Jonna, great point, but I'm gonna have to cut you off because we are.
Iowa Code Section 321.263 was enacted for 2 reasons. And it's in the legislative history that we've provided to the court. It's also, it's easy to get there this way, declared by the Iowa Supreme Court in the 7 case, which is in our briefs and motions. So 321.263 started out years ago, Your Honor, in the 1930s. And then in 1970 or 71, there was a set of circumstances which gave rise to the 7 case. And 321.263 prior to that said you've got to give the information to the other person, the other driver. In 7, the other person was a pedestrian who had clearly and unequivocally been killed and was dead and or unconscious. And 7 didn't give the information and left and was charged under the statute. And a verdict was directed in favor by the court of the accused in that case because the statute did not tell a driver, Mr. 7 in that case, to whom to give that information in the event the other driver or person is dead or unconscious. And it was impossible for him or any citizen in that case to comply with the statute. And the statute didn't tell him what to do in that case. The 7 case was strictly narrowly construed in favor of the accused in that case, consistent with the rule of lenity, consistent with the commands of due process, because if we're loosey-goosey about it and we're broad in our interpretation, people aren't given reasonable notice. One might have concluded in that case, well, it's obvious if the person's dead, you should, well, this was 1970, so there weren't cell phones until 1972. It's obvious, just leave the information at the scene next to the dead person. But it didn't say that, and the court didn't interpret that that should be understood by the statute, because statutes and prohibited behavior that has been criminalized and the due process clause doesn't allow just general understood to be part of the argument and the equation when we're talking about the constitutionality of the statute and the due process rights of an individual. As a result of that, 321.263 was then amended shortly after the 7 case in 1971, still 1 year prior to anyone in the country even knowing what a cell phone was. And it specifically said that, so by the way, 7 makes it very clear that the amendment after the 7 case from 1970 was done to clarify the law. not to expand it, not to create new law per se, not for new purposes or new designs, but to clarify it. So they clarified what you do in the event somebody has died. And when somebody has died, obviously you can't give that information to them. So the amended statute in 1971, which resulted in this, which is before the court, included that, okay, you must leave your identifying information on the scene. And you must call law enforcement and notify them of the accident. Nothing was changed, really, other than that. And nothing was added to require remaining on the scene until a cop arrives to look at you and size you up, which is the only thing they can try to contend is the basis for any charge against Mr. Solch in this case. So, but what that circumstance did was not only lead to that clarification in the statutory provision, Your Honor, it led to an enlightenment to the people of the state of Iowa, citizens, about what the purpose of 321.263 was. And the Iowa Supreme Court in 7 said it's clear what the purpose of 321.263 is. Two purposes. To make sure a driver who causes an accident, and this is the classic hit and run scenario that people think of. One purpose is to make sure that a driver who causes an accident doesn't take off and is allowed to obfuscate his or her identity and conceal his identity and evade responsibility and evade liability for an accident that caused death. That's number one, which is what people think of, hit and run. We want to make sure you don't get away with it without people knowing you caused an accident, without people knowing who you are. And number two, the Iowa Supreme Court said that the other purpose is to make sure that if it's an injured party on the other end of the accident, that they receive aid, that you remain until aid is given or received. Or if it's a dead person because of the accident, that you remain until authorities arrive so as to protect the person or body from further distress or the danger from additional mutilation, even of a dead body laying along the road. That is the purpose of 321.263, to make sure we know who you are and to make sure one of two things. Either the person is getting aid if they're not dead, or if they're dead, that you stay there until authorities get there so people aren't running over a body and there's not further distress and humiliation disrespectfully to a human body. Nowhere in there does it say how long you must remain. The canons of statutory interpretation say we can infer how long you're supposed to remain by the purposes and intent of the statute. And that's where we go to the legislative history and the judicially declared intent. So, although remaining until authorities get there to provide aid and remaining until authorities get there to attend to the dead body also is not written into the literal language of the statute. It is inferred in the statute by the literal language of the statutory history in the legislative history and the literal language of the Iowa Supreme Court in the 7 case that literally publicly declared what the two purposes are. So obviously the statute was written to accomplish those two purposes. If a person doesn't stop at all, they're in violation of the statute. And if a person doesn't stop at all and is charged for this hit and run, for not stopping, that person has no standing to declare that this statute is unconstitutional as applied to them, because the facts and circumstances of that case would be a person who didn't even stop at all. If a person stops and renders temporary aid, or even renders aid until medical responders arrive or attends to a dead body until governmental officials arrive, and then takes off without ever notifying law enforcement who they are and providing their identifying information, then they're in violation of the statute, because the purpose of the statute is to make sure that that doesn't happen. So if you don't stop at all, you're in violation of the statute. If you stop and you give aid but you don't give your name, you're in violation of the statute. If you stop and you call and you give your name and it's a dead body or a severely injured person and you don't stay and help them and you leave them just hanging there until somebody else comes along, then you're in violation of the statute, because the purpose of the statute was to make sure those didn't happen. It hasn't happened here. Mr. Souls stopped. Mr. Souls reported it. Mr. Souls provided his identifying information. Mr. Souls provided his role to law enforcement in the accident. Mr. Souls provided medical aid or personal first aid. Mr. Souls stayed and attended until governmental authorities arrived. Mr. Souls did what the statute is designed to have people do. Mr. Souls did not do anything he was prohibited from doing under the statute. Had he left before doing those things, he would have been in violation of the statute. Does this tell us how long they have to remain? No. Does it specifically say until a cop gets there and sizes you up? Clearly no. Does it specifically say until authorities get there to attend the body? Not literally in the language, but in the legislative history and then judicially declared purpose. So we know from the legislative history and judicially declared purpose that if those two are complied with, it's not prohibited conduct. Now, the state, in arguing that you have to stay until law enforcement comes, not only would be in violation of the rule of lenity, but the state would also be putting forth a contorted interpretation that violates Mr. Souls' rights under Article 1, Section 1 of the Iowa Constitution, enjoying life and pursuing happiness, and Article 1, Section 8, right to be free from unreasonable seizures and the requirement for probable cause. Let's talk about that, Your Honor. So, by the way, those are fundamental rights. The first two are literally Article 1, Section 1. Can't get much more fundamental right than that in the very first section of the very first article of the Iowa Constitution. The right to be free from unreasonable seizures and the requirement of probable cause are also fundamental rights. When it comes to the jurisprudence of statutory constructions as to the constitutionality of criminal statutes, if the statute affects a fundamental right, then the burden is on the government to prove that the statutory provision is necessary and narrowly tailored to accomplish a compelling governmental interest. Necessary for a compelling governmental interest. So, what does 321.263 require of a citizen as it implicates their fundamental rights? It requires that when you get in an accident, you got to briefly stop and give aid until aid is no longer necessary or until authorities come. Is that a restraint of your freedom of movement to some degree? Yes. But is it an acceptable restraint of your freedom of movement to accomplish one of the purposes of the statute, which is to make sure that seriously injured people aren't left unattended, or that a dead body isn't disrespectfully left unattended to risk further distress or mutilation? No. Those are reasonable compromises of your ability to move about. You're also required to report the accident and provide your identifying information, who you are. Even under the Fifth Amendment, it's generally recognized that you have to identify who you are. You don't have to say what you did. You don't have to say where you might have to say where you live, at least for purposes of showing your driver's license. But beyond saying who you are and where you live, you don't have to say anything under the Fifth Amendment. And that's what this case is concerning about, because the newly added, from their contorted self-serving view, interpretation by the government wouldn't just have those fundamental rights infringed until we find out who you are for purposes of your identity, and wouldn't just have a restraint on Mr. Soul's freedom of movement and right to pursue happiness and right to do whatever the heck he wants as a citizen, just until somebody gets there to help the injured party or to attend to the dead body now. No, the government wants even further, broader restraints of his fundamental rights and liberties, and wants an interpretation that declares, from where, I don't know, you got to stay even longer, and you got to give up your right to pursue happiness, and you got to give up your right to enjoy life, and you got to give up your right to unreasonably be seized as a person until a cop gets there to look at you and size you up. Are the first two reasonable infringements on rights to accomplish a necessary purpose of a legitimate statute as declared by the legislative history and as announced by the judicially declared purpose of the statute? Yes. But is compromising the fundamental right to enjoying life and pursuing happiness, and, importantly, to be free from unreasonably being seized as a person without a warrant, without judicial intervention, without finding a probable cause or reasonable suspicion. They want the court to somehow broadly interpret the statute to say that those infringements are okay for the sole purpose of making a police investigation a little more easy. That is unconstitutional. And therein lies the problem in this case. Your Honor, once Mr. Souls appropriately and responsibly reported the accident to law enforcement and provided his personal identifying information, and once he appropriately, compassionately, and responsibly remained on the scene with Mr. Mosier and Mr. Mosier's body until emergency governmental authorities arrived, once those two things had occurred, which are the only two purposes of this statute, as declared by the legislative history and the judicially declared announcement, once those two things had occurred, at that point, the state lacked a sufficiently compelling justification for infringing on his fundamental right to be free from unreasonable, warrantless personal seizure of his person. They want you to say they have the right to make their investigation easier so they can look at him and size him up. But remember, the law is perfectly fine with a person navigating between legal obligations and their own individual rights and liberties. Now, there's a recent Iowa Supreme Court case, Your Honor, Santee versus Santee. It's a 2001 Iowa Supreme Court case, S-A-N-T-I. It wasn't a criminal statute, but it's a civil statute regarding grandparent visitations. And here's what the Iowa Supreme Court said regarding that. And it has some important analogy here. Quote, without a threshold finding of unfitness, the statute effectively substitutes sentimentality for constitutionality. It exalts the socially desirable goal of grandparent-grandchild bonding over the constitutionally recognized right of parents to decide with whom their children will associate. It exalts sentimentality to constitutionality. Who would argue with grandparents being able to see their grandchild, right? And in the Constitution, if there isn't a showing of unfitness of the natural parent, everybody would assume a statute like that makes common sense. Everyone would assume you wouldn't deny grandparents their right to visitation, but it exalts sentimentality for constitutionality. How does that apply in this case? The state's interpretation of the statute. Now, by the way, Your Honor, the strict scrutiny analysis only applies if somehow the court gets way advanced into buying into their interpretation, which isn't anywhere in the language or anywhere in the history. But if the court believes it requires one to remain until a cop gets there to size you up, even after remaining for all those other things, then that's the state's interpretation in that regard, which, by the way, isn't anywhere in the statute, substitutes societal and or police preference for the desirability, substitutes societal or police preference or desirability for constitutionality. It exalts the police law enforcement desire for an observational look or peek at every driver over the constitutional requirement of probable cause or reasonable suspicion before one is deprived of their liberty and freedom of movement. No one denies that they have preferences for police investigation. But Mr. Soules and every citizen can navigate between what he's legally obligated to do, which he did, and his personal individual rights and liberties, which are quite frankly more important because they're written in a 250-year-old constitutional provision. So, because the statute is ambiguous as to how long he must remain, the court must interpret that ambiguity in favor of him as the accused, and interpret that ambiguity given the legislative purpose and intent to make sure you don't get away without us knowing who you are, and to make sure somebody is attended to or a dead body isn't left alone. And those two purposes are interpreted to be how long you must remain. Remaining longer for a police view contorts the statute against the accused and in favor of the government, in violation of the rule of lenity, which would be in violation of the Due Process Clause, which says you must be given fair notice. Nowhere in that statute does it say how long. I would challenge the attorneys for the state to show the court anywhere in the statutory provision where it says you must remain until a cop gets a look at you. Nowhere in the statutory history, I challenge them to point out to the court, does it even mention OWI or getting a peek at the defendant. Nowhere. Nowhere in the judicially declared from Iowa Supreme Court decisions does it declare that you have to stay until a cop gets a look at you. So, this statute existed prior to 1970 in that unusual set of circumstances that led to the 7 case, and then the 7 case came out. And if after 7, which was 1971, by the way, cell phones came in 72, Your Honor. The authority for that is in our brief. So the statutory provisions here were written without knowledge or understanding that you could call and report an accident and give your identifying information literally from the scene of the accident. But if after the 1970-71 amendment that resulted in this, and the 7 case, any citizen, any lawyer, and any judge were to sit down and read this statute, and then sit down and read the legislative history, and sit down and read the judicially declared purposes of the statute, which not everybody does, but that's how everybody would know about the laws and what they mean. Nobody would come away from that analysis and research and reading and review with a clear belief or understanding to any degree that you're prohibited from leaving after you've done all those things until a little longer, until a cop gets a good look at you. And if a citizen can't get that from the statute, or from the legislative history, or from the judicially declared opinions of our highest court, then it's constitutionally vague, and this court must decide. Do you have to remain on the scene? No one doubts you have to remain on the scene. Do you have to remain on the scene until those two purposes are accomplished? Yes. How do we know that? Because of the declared intent and purpose. Do you have to remain longer until they get a good look? No, because it doesn't say that anywhere in any of those things, and the ambiguity has to be against them and in favor of Mr. Souls. At this time, I would rest until rebuttal argument. If the court has any questions at this time, I'm happy to address them.
Brown?
Thank you, Judge. My remarks will be far more brief than Mr. Montgomery's. First of all, I want to bring you back to the rule that this motion is filed under, which is 2.11.6. And the pertinent part of that rule that applies reads as follows. If it appears from the information and the minutes of evidence that the particulars stated do not constitute the offense charged in the information, then it can be dismissed by the court. In looking at what the facts are that support the charge, it's our position that you're confined to the minutes of evidence in the case as pled. As a very fine closing argument that Mr. Montgomery made, but we're not here to determine the guilt or innocence of Mr. Souls. We're here to apply the standard as is set forth in the rule that's been pled by the defense. Both motions to dismiss were filed pursuant to that rule. So I just want to address a couple things with regard to Mr. Montgomery's argument. First of all, the 911 call was played. I believe it's about 5 or 6 minutes long. The call was made at about 8:20. It was made at 8:20 p.m. And at the end of it, you'll hear the 911, the dispatcher, ask Mr. Souls. There's some promise that he's going to call her back. He never does that. There is radio traffic, I think, that's also on that exhibit. If you listen through the end of that radio traffic, there is no call back. From the minutes of evidence that are pled, the first law enforcement officer on the scene arrived at 8:34 p.m. At the time, it was Deputy Ben Ward. At the time that Deputy Ward arrived at the scene, there was no Mr. Souls. He had gotten into a red truck that had been provided by another person on the scene that we believe was related to Mr. Souls, and he left. There are two local resident eyewitnesses who were present at the crash, as well as a truck driver. The truck driver is referenced in the exhibit regarding the facts that the defense, I'm not sure what you're going to call that exhibit now, Exhibit C.
C is the facts.
Okay, references the truck driver. At least the two residents, local residents at the scene, observed Mr. Souls driving away in this red truck. So he was on the scene of this crash from the time that he called the 911 call until just before, or sometime before Deputy Ward arrived. So less than, even giving him the benefit of the doubt that he left as the Deputy Ward was arriving, it was 14 minutes, or most likely less, because Ward did not see him leaving. He left east down a gravel road in this truck. So he remained at the scene for that short of a period of time. I would tell the court that even the witnesses on the scene, the truck driver, other witnesses that were present, another motorist that was there, all remained longer than Mr. Souls. Again, because it was a serious crash that had resulted in the death of Mr. Mosier. So if we look at this statute, basically what the defense is making is a sufficiency claim that's wrapped up in a constitutional argument, but what are the reasons that we have this particular statute? Why would we want someone to remain at the scene, particularly of a fatality crash, What would be some of the policy considerations behind this? First off, we need to make sure that all people that are involved in the crash are identified. Because it's a fatality, there are these additional requirements that are found in subsection 2 of that particular statute. But because this is a fatality, it is necessary for law enforcement to at least have a face-to-face interaction with those that are involved. Now, Mr. Montgomery spent a lot of time making reference to where is that in the statute. There's nothing that's specifically delineated in the statute that requires that. However, if you look at section 2 of the statute, if the accident causes the death of a person, all surviving drivers shall remain. They can leave for 2 reasons. 1 is to seek necessary aid, or 2 is to report the accident to law enforcement. All right, if you're going to, Mr. Montgomery spent a lot of time on how much or what Mr. Souls did to assist Mr. Mosier after the crash occurred. Nothing referenced law enforcement. Our position is, as is stated in our brief, that the remain at the scene infers that the person shall remain until those 2 things happen. Rescuers arrive to assist the person who's injured, and law enforcement authorities arrive. Mr. Souls did not wait for the police. He was there less than 14 minutes at the scene. I would submit that people who have a fender bender are at a crash scene longer than Mr. Souls. Mr. Montgomery talks about moral responsibility. Doesn't he have a moral responsibility to remain at the scene until at least those 2 things happen? At least. The statute clearly infers that. Why would that be the case? And this is not necessarily to collect information for a criminal investigation. I mean, people that, the family of Mr. Mosier, those that are involved in the crash, have a expectation that identifying information is collected from drivers, that the collection of other evidence or other information is collected from drivers, and that all that information is accurate to the best of law enforcement's ability. How are they supposed to do that if one of the persons involved in the crash scene leaves before law enforcement even gets a chance to look at him? There's no broader restraint on Mr. Souls than if he had been stopped by the police and been investigated for drunk driving, where they can request that he submit to field sobriety, they can make observations of him. There's certainly no broader restraint than that that would have been required here. So what was, I'm not sure the morally responsible thing is really I think the statute does address that, but if you want to talk about what the morally responsible thing to do would have been, it would have been to stay, at least until law enforcement arrived. I think the statute infers that. If all it would have required is that he get help from Mr. Mosier and then he can leave, then why the other clause in subsection 2 that by law enforcement? Clearly, those 2 things are critical to the statute. They're critical to aid to those that are at the scene to determine what happened, to come to the truth of what occurred. Mr. Souls' leaving the scene leaves many ambiguities as to why and how this crash occurred. That's why we have the statute. That's why he should have remained at the scene. The facts as pled are sufficient in this case. They satisfy what's required by the rule, what's required by the case law that we've cited. All of the constitutional arguments with regard to what Mr. Montgomery has raised have all been addressed. I think we have over 100 pages of brief that total, both sides together, have submitted to you. I don't need to reiterate the cases. I don't need to reiterate those arguments for purposes of this presentation today. I think our position is clear with regard to the constitutionality of the statute and whether or not the facts as pled are sufficient, and we'd ask that both motions be overruled.
Thank you, Your Honor. May it please the Court. It wasn't a closing argument. It was a constitutional argument. It was a constitutional argument addressing the facts and circumstances of this case as reflected by the minutes of testimony filed by the state and as reflected by the exhibit entered into this case. This is no light situation, Your Honor. We don't expect it to be made light of. This is a very serious matter. Now, the attorney for the state, interestingly, did not accept any of my challenges. Tell the court where in the statute it says you don't just have to remain until the purposes of the statute are complied with. You have to remain even longer until we get a good peek. Didn't answer that question. Didn't answer that question because it can't be answered. And if it can't be answered, you can't hold a citizen criminally responsible if the Attorney General can't even articulate it after all of this. And that's why we have due process. And that's why we have the rule of lenity that says, yeah, okay, by the way, the rule of lenity will say this, Your Honor. Even if Mr. Brown and the attorneys for the state have what might be a reasonable argument, if the accused has a reasonable argument, and by the way, this is really what it boils down to, Your Honor. As it comes to the constitutionality of the statute, we do, in fact, affirmatively urge this court to engage an independent approach under the state constitution, specifically under Article 1, Section 9 of the Iowa Constitution, which is the due process provision. And due process provision requires the clarity and the advance notice of what is exactly prohibited. We urge the court in engaging this independent approach under Article 1, Section 9 of the Constitution to approach this way. If a statute is vague in a situation such as this, for how long a person should remain until the occurrence of some unknown event, if a reasonable reading of the statute is combined with the purpose of the statute as reflected by the legislative history in the published state of Iowa legislative history, and if a reasonable reading of the statute as reflected by the declared intent and purpose of the statute in officially published and promulgated Iowa Supreme Court judicial decisions, if all of these accomplishing those purposes, if a reading of the statute proposed by the accused supports and accomplishes the intended purposes as promulgated by the statute and the history and the Supreme Court, then if a statute is ambiguous as to how long one needs to remain, and that put forth by the accused is reasonable under a reading of the statute and combined with all those things, and that which is urged by the accused actually accomplishes the stated legislative and judicial purposes and intent of the law, then the defendant's interpretation, if it accomplishes the purpose, making sure you don't get away without us knowing who you are, and making sure a person is given aid and not left dead, and subject to additional distress and mutilation until authorities get there, if all of those are accomplished under that reading reasonably urged by a citizen, in this case the accused, Mr. Souls, then the defendant's interpretation must be accepted pursuant to the due process provisions of the Iowa Constitution. Now, this is not really any new law. This is essentially the rule of lenity from the authorities I cited at the outset to the court. And the rule of lenity comes out of, and it is embodied in, the due process clause. Mr. Brown, the attorney for the state, can't tell the court, it's one thing to tell the court, let's infer that the statute says you got to stay until a cop gets a look at you, even though you stayed quite long until all those other purposes of the statute were accomplished. It's one thing to say, well, we can infer that that's what it is. From where does the state offer that inference? They just want the court out of whole cloth to say, it's inferred that you got to stay for a cop to get a look at you. Didn't say where it came from. Can't say the legislative history because it's not in the legislative history. Can't say the purpose and intent of the law because it's not in the purpose and intent of the law. Can't say the plain language of the statute because it's not in the plain language of the statute. Can't say the intent of the law as publicly promulgated by a published decision by the Iowa Supreme Court because the Iowa Supreme Court says those are the two reasons. Nowhere in any decision or any case, anywhere, has it ever been suggested that one must remain even longer after doing all those things so a cop can get a good look at you for investigative purposes. And the attorney for the state talked about a lot of ambiguities, which 99.9% of those ambiguities would not be resolved if Mr. Soules had remained and exercised his Fifth Amendment rights. They want to know more things from Mr. Soules, and because they have an inherent prosecutorial, police investigative curiosity for those things, they want the court to assume that that means it's inferred in the statute, and that's not how it works. That's not how it works at all. Just like the grandparent visitation. Sentimentality over constitutionality. Who would argue that grandparents should be able to see their grandchildren? The Constitution is still the Constitution. He wants to argue, who's going to argue that you should give a bunch of information out? Anyone can do that if they choose to, but they can't be compelled to. By the way, even a plain reading of the statute, Your Honor, makes it very clear that the statute presupposes that the driver of the car would not remain on the scene. Because it says, after leaving the scene of the accident, so it presupposes you would leave. Now, by the way, again, 1970, Mr. Brown, the attorney for the state, wants to say, well, you can only leave under these two circumstances. Well, not really true. You can only leave under those two circumstances in the circumstances of the year 1971 if the only way in 1971 you could report an accident was to leave the scene of an accident to get to a payphone or the nearest house phone. And then when you did have to come back, or you didn't have to come back, and you could just call police. So even the actual language of the face of the statute from 1971 presupposes if you left, which in 1971 was only supposed to be for purposes of reporting the accident because they didn't have cell phones. By the way, that meant return until something else occurred. That didn't mean return, that still doesn't answer the question, return and remain for how long? Remain until authorities get there to give aid, remain until authorities get there to attend the dead body, or the contorted view and the self-serving police prosecutorial view remain even longer so we get a peek at you. That still doesn't answer that question. And that question remains ambiguous. And if the purpose of the statute can be satisfied by remaining long enough. Now, the attorney for the state said, that's how short he remained. Well, we tell, Your Honor, that that's how long he remained. And Mr. Soules remained long enough, according to the minutes of testimony filed by the government, for Kevin Quast to arrive on the scene, for Vincent Book to arrive on the scene, for Kaylee Cope to arrive on the scene, for Captain Sean Opitz of the Aurora Fire Department to arrive on the scene, for Darlene Fells to arrive on the scene, for emergency medical responder Michael Hundley to arrive on the scene, for emergency medical responder Kim Wessels to arrive on the scene. He remained there long enough for all of those two things to occur. He remained there long enough so emergency governmental authorities were tending to Mr. Moser. He remained there long enough to give his identity. He remained there long enough for two of those 7 people to come in a government responding vehicle with lights and sirens. He remained long enough for all of those. Now, what if a reserve officer in a law enforcement van had arrived and picked up the body of the decedent, put it in the van, and taken it away, according to the state's interpretation, he could have left then? Or what if the ambulance arrives and takes the body away, and there's no longer anybody that he's tending to either for serious injuries or attending to make sure there's no further distress or mutilation of the dead body? Then they're saying Mr. Souls, under the statute, still has to remain even longer than that? And by the way, if that's the case, you got to put it in the statute. And because it's not in the statute, you can't infer it to be in the statute because that violates his due process rights. But if you do infer it to be in the statute, Your Honor, it doesn't pass strict scrutiny because it's got to be necessary for a compelling government interest. So even if you believe the statute requires that, an investigatory curiosity pique is not a compelling government interest, compelling enough and narrowly tailored enough to violate the rights of citizens like Mr. Souls. By the way, he left the vehicle that he was driving that was involved in the accident at the scene with plates posted on the vehicle, with the registration stickers of the vehicle displayed on the vehicle and on the plates, and with the registration and registration number of the vehicle involved in the accident on the scene. He stayed long enough for all of those things to occur and for the purpose of the statute to be satisfied. By what right does the government have to say, after doing all of those things and remaining for all of that, you still got to stay longer to make our investigative job easier? That's unconstitutional. The court should find it ambiguous and vague and interpret the vagueness based on the rule of lenity in favor of Mr. Souls and make a finding that because it doesn't say you have to remain here or here, that it's got to be the reasonable interpretation that accomplishes the goals of the statute pursuant to due process. And the court, if they find somehow that contorted view is in the statute, should judicially conclude that under strict scrutiny it doesn't pass analysis because just getting a police officer's cop's curiosity view or peek at a driver is not a compelling government interest. For all those reasons, we urge the court to conclude that the statute is unconstitutionally vague, interpreted in favor of Mr. Souls. If interpreted in favor of Mr. Souls under 2.11 of the rule, with the trial information and the minutes of evidence, and that statute interpreted in favor of the accused under the due process rights, there is no showing in the minutes of testimony and the allegations filed in this case that he has violated this statute. And by the way, 211, we acknowledge a traditional 211 motion, Your Honor, 2.11 motion, is limited to no additional evidence. But this is more than just the traditional 2.11 motion. This is a motion to dismiss based on the unconstitutionality of the statute. We have provided authority to the court on it is appropriate for the court to consider facts and circumstances of the case when it deals with determining the constitutionality of the statute as applied, which is beyond just the classic narrow 2.11. Under 2.11, this statute has not been violated by the minutes of testimony. Under vagueness as applied, this statute says he must remain only until he's provided his identifying information and only until aid has gotten there for the deceased body. That's it. For that reason, we ask the court to dismiss the charges. I would entertain any questions the court has regarding the facts, the law, or our interpretation of it.
Mr. Brown, how long will the state need to submit its response to Exhibit C?
Can you give us until 10 a.m. tomorrow morning?
I will do that. 10 o'clock tomorrow for your response. Counsel, I will take the matter under advisement. I'm going to review your written briefs and the authorities you've cited in light of the arguments you've made today. So I want to go through them again now that I've heard your arguments. Thank you very much.
Thank you.
Thank you. we need to upload Exhibit B to the FCC. Yeah, I'm gonna call these steps. Did the judge actually get so this is Exhibit A. So this is because of the user.
Welcome back to the Law&Crime Network. My name is Stephanie Willis, and I'm here with Aaron and Jonna, and we have been watching these arguments that have been made by the defense. Mm-hmm. I'm going to say the arguments made by the defense because the prosecution really hasn't made their arguments, because we know that the judge has taken everything under advisement and the state has 24 hours to submit their response. Mm-hmm. So they'll be submitting their written response tomorrow. But what are we thinking about the arguments that have been made by the defense here, guys?
I didn't think that the state did a very good job of arguing that the plain reading of the statute indicates that the defendant can't leave until law enforcement, in other words, the police, show up. Now, my reading of it suggests that that's the proper way to read it. And at one point, the state was saying, well, it infers that that's what it means. Well, statutes can't infer things. They either say it or they don't say it. So the state's argument was wishy-washy. At least that's what I thought.
I agree with you. And in fact, by saying that the statute inferred one thing over another, the state's basically making the defense argument, because the defense is claiming, look, when you have an ambiguity like that, you have to rule in favor of the defendant. That's the rule of levity, or what he was citing there. You have to rule in favor of the defendant. And I'm assuming the judge is going to consider, look, you don't win just based on the number of words you say, because if you did, the defense would definitely win that. Yes. But the judge is going to have to consider how the facts apply to this particular law. And the defense made a great argument. Where the judge might have a problem is that, is it a matter for her to decide, or is the defense really arguing facts that are best in front of the jury to determine whether or not this defendant is guilty of this particular crime? I think the defense put on a great argument. Mm-hmm. It was well spoken. It was well thought out. Made a whole lot of sense to me. Absolutely. And what he was saying, basically, that the defendant did everything that statute requires of you. Made the call, stayed there, rendered aid, and the only thing that he failed to do was make the, quote, police investigation easier. He kept coming back to that argument. And I would agree that that's not what the statute is for. The statute is to help the injured/dying person at an accident scene, and Crystal's satisfied those elements.
I have to agree with you there, Jonna. I think the defense made a very great job articulating and breaking down the statute. I thought it was quite interesting that he brought up the legislative history behind this particular statute, especially discussing the portion from 1971. And I think that he talked about the two factors that had to be considered. I believe one in being like, well, if you have to go find or go to another residence in order to make a phone call, because we did not have cellular phones really at that time in 1971, then you know, go ahead and make that call. But it did not state how long, once you returned, how long you had to remain. Right. He also went through,
you know, and see, that's the thing, is that's the argument. But look, I mean, to me, the plain language of the statute, and this is what the state should have said, is look, it says you have to remain on the scene, and you can leave for one of two reasons: either to seek necessary aid or to report the accident to law enforcement authorities. So if you don't need to leave to report it, therefore you have to remain. It's very clear. You stay until you either report it or you.
But it was reported.
Right. No. But it says you only get to leave if you need to leave to report it. He didn't need to leave to report it. He pulled out his phone, so he chose to report it from the scene. Therefore, he has to stay.
And that's what the state should have argued.
Yeah.
But it didn't. And the other and to that, the other interesting thing the defense attorney said was, well, wait a minute. Let's suppose hypothetically the police show up and they take the injured person or the dying person. No, this is what he said. What do you have to stay after the police have already done their thing? Like once the paramedics take the injured person away, person's no longer there. You just sit on the side of the road and wait for the police to show up? Because to me, that doesn't make a whole lot of sense either. If the purpose of waiting for the police is to report the incident, and they know about it, and the paramedics have arrived, and the now injured person is not in peril any further because he's in the back of an ambulance, you got to stay.
But the statute,
you
see,
read
this
the
is the
statute,
thing.
you do.
The statute doesn't say that you get to leave after you report it. It says you can leave in order to report it if there's no other way to report it.
And then what is the purpose? According to the statute, this is the other argument, why would you have to stay there if it's already been reported and the injured or / deceased person is no longer in any peril? Why would you have to sit on the side of the road and twiddle your thumbs?
So as to not destroy evidence.
And therein lies the Fifth Amendment argument. So we come full circle. This is not going to be, I love the way the defense broke this down. I don't think it's going to be a slam dunk for this judge to make her decision. Even though the state, they should have had you at their table. It would have been a little bit more even, the playing field. But it's not going to be an easy decision, and it's a very important one.
I think that it's extremely important because I think at this point, everyone's looking to this particular statute to see how they should perform after an accident occurs, or what should be done after an accident occurs. Because if that's the case, then anybody can do exactly what Chris Soules did, as we were previously discussing, and do the same thing and hope to get off.
Because you also have to remember, you're absolutely right. You cannot infer that anytime somebody does what Chris Soules did, that they were drunk.
Right.
And the one thing that the prosecution did manage to squeak out was, well, what if he had been intoxicated? But we don't know that. We'll never know that, and you can't use that against him in this case.
And I think that's pretty much, as you've stated from the beginning, what the prosecution is trying to do here.
Beef.
That's it. They weren't able to complete their investigation, and so now they have to bring in this particular statute in order to catch him on something.
Yeah, they can't get him on anything else. So
Right.
look, there are a couple procedural breakdowns here. First of all, the legislature should be looking at the language of the statute and saying, hey, look, is this what we really wanted this to mean? Were we trying to make it mean something else without sounding like that's what it means, to try to prevent teeing up the constitutional analysis?
Right.
That's one thing that needs to be examined here. The second thing is, why did it take them forever to get a warrant to go into the house and get him? That took forever. And in today's day and age, usually police are able in a lot of jurisdictions to just call up a judge on a phone or send a text message and say, here's what we've got, can we go in? And that functions in many places. But in this case, it just took them forever to get the ball rolling, to get the ball anywhere close to the end zone where they could get in and do a blood alcohol test. The way that I read this thing, though, we've discussed, but here's the problem with the defense's case here. And I agree with you. I'm just arguing with you. I think they've got a good argument. The thing where their argument falls flat is this whole, he's there and he waited for the paramedics to show up, and when they showed up, he left. Well, see, that's the weak spot, because the statute says law enforcement authorities. I don't think anybody would argue that paramedics are law enforcement authorities. Law enforcement authorities are probably state police, assuming that they have one in Iowa, or some kind of state highway patrol, your local police department, your county sheriff, constable, whatever. That's law enforcement authorities. That does not say any vehicle with flashing lights that can display flashing lights. So what do you wait? Is he trying to say he can leave as soon as the tow truck driver shows up, the paramedic, the school nurse? Like, it says law enforcement authorities.
But then back up, because the defense attorney also said, if that were the intent of the statute, then that language should be in the statute. It should say you must wait for law enforcement authorities, and then you must give them a statement, which would run counter to the whole Fifth Amendment argument again. Just like the statute doesn't say if you leave, you have to answer the door when the police show up and knock on it after an accident. You don't have to provide them with evidence that incriminates you. And it certainly wouldn't be language in the statute. It's not language in the statute. And I think that's an important point that the defense is making here.
Well, okay, so guys, I have to talk about something real quick. So when we're looking at the statute, it says, to Aaron's point, if the accident causes the death of a person, all surviving drivers shall remain at the scene of the accident except to seek necessary aid or to report the accident to law enforcement authorities. However, it says before leaving the scene of the fatal accident, and this is what the defense attorney was saying, before leaving the scene of a fatal accident, each surviving driver shall leave the surviving driver's driver's license, automobile registration receipt, or other identification data at the scene of the accident. So essentially, he's complying, is he not?
Right. That is
I don't
the
know.
argument.
Did he leave it at the scene of the accident, or did he phone it in?
He phoned it in from the scene of the accident.
Okay, well that's not leaving it at the scene of the accident, so maybe he violated that part.
Well, he
of
left
it.
his registration, they said, because he left the vehicle.
Yep.
He didn't leave with the car. He left with the vehicle. The vehicle had the vehicle registration in it. So, I mean, does that help the defense's case here a little bit?
I say it does.
Well, it probably. Well, I'm sorry. Go ahead.
No, because the whole purpose of the statute isn't to aid law enforcement in its investigation, because that runs afoul of the Fifth Amendment, and he even alluded to the Fourth Amendment, unlawful seizure, search and seizure. So the purpose of the statute is to protect the dead and dying at a fatal accident scene. That is the purpose. And if you take the facts of the case and you apply them to that purpose within the law, Chris Soules is not guilty of anything.
I have to agree with you. Aaron, what do you think?
Look, I'm curious about a couple of different things. A, I want to know how every other state deals with this. B, I want to know if it's been challenged in this way before. And C, I want to know how it's been ruled upon. Now, the defense here seems to indicate, this is, there's nothing that would go contrary to the way we're arguing the point. But part of me wonders, hey, look, is this the tried and true response to this kind of charge in Iowa that the judges have already punted, or is this a novel thing that, even though this law has been on the books since at least when they were saying at least the 70s or something, is this suddenly we here in 2017 have this new novel way of trying to knock it down in this circumstance because we've never had these facts before? Part of me wonders, because look, I mean, defense attorneys in a lot of states have their forms, and every time somebody gets charged with something, they've got some case either locally or sometimes in another state saying, well, we should adopt this approach, and they try it again and again and again and again, and every time the judge says no, no, no. So part of me wonders, okay, is this novel in Iowa, or is this a new way of looking at it because we've never had these facts before?
I think you're onto something, because typically, let's go back to why any state has a statute like this. You have these statutes to avoid this. I run into the back of your car. Maybe I'm stinking drunk, maybe I'm not, but you're unconscious, you're not able to give a statement to the police, and I beat feet before anybody shows up, so you don't know if I was there, if I was driving, whose car it was, none of that. That's typically how a leaving the scene gets charged, and there's no question that that's a violation of any statute. But here, when you have a guy who's basically complying with all the terms of the statute, except he's not physically at the scene after the police get there, then how can you? Do you think 12 people in jury box, if the judge says I'm gonna let this issue go to a jury, you think 12 people are gonna say that this guy is guilty of leaving the scene after he provided all that information?
I think they will. I mean, I think they're going to look at it. I agree with you. I do, but I think that they're going to look at it and they're going to say, well, he left. Ultimately, he left, even though he called, even though he waited for a few minutes, even though he left his registration, even though he left his vehicle. The point is that he left and there was a dying man.
Well, and then that's why the defense has to hope the judge fetters this one out for him on a legal basis, as opposed to the factual basis. But this
and
really bugs
if
me.
not, then he should, if it stays alive, he should go for a bench trial.
Yeah, that would be smart.
Depending on what she says in her decision.
Yeah.
Because if she
Well,
comes
that's
back
true.
and she's not a very happy judge. Like, she looks very, very stern, and we don't know. Maybe in her mind she could be siding with the state in her mind, even though she's not allowed. She has to be, fair and impartial. So you wouldn't want to judge if a judge gives you a wink and a nod, like, I hear where you're coming from, defense counsel. Then you might opt for a bench trial. But otherwise, your safer bet is to at least not convince, or have one of the 12 jurors not convinced that this was an actual crime.
Well, we're going to switch gears here. I know that this was some riveting. This was quite riveting.
It was exciting for me. It was better than Law and Order. I really loved it.
It was great. I mean, we had a crime scene. We had constitutional arguments. It's the best of both worlds that we got going on, right?
Well, look, I mean, it points to an issue that a lot of times we talk about here, and that we hope that the trial watchers are keying into. It's like the literal language of the law is where the details are in this.
Absolutely.
And if that law doesn't cover that conduct, it doesn't matter whether people are mad at him, whether they think he should have hung around. If an argument can be made that the statute doesn't cover it, then he walks. And if people are mad about that, then the next step is, look, right to the legislature.
Yep.
Do you two have a prediction as to how you think the judge is going to decide on this one? Or
Yes.
will you say it on the air? Are you off
I
the air?
think that the judge is probably going to look at it and say statutes are presumed constitutional when passed. There's a presumption of constitutionality. My guess is that this judge and most trial judges will keep the case alive. If there's an acquittal, the issue goes away. If there's a conviction, let the Court of Appeals or whatever the next jump up is in Iowa
Right.
take a look at the issue, because a lot of local judges do not want to be seen as flipping the constitutionality of a statute on an argument at this stage of the game. That's my guess. I've been wrong before, though. I might be wrong again. If you want to disagree with me,
No,
then
no. As a matter of fact, I was agreeing with you. I mean, judges tend to like to walk a fine line, and they don't want to overturn, as you stated, the constitutionality of a particular statute, especially when it was brought through the legislature. I don't think that they do that unless it's like particularly egregious. So I do think that she'll probably err on the side that the statute in itself is constitutional, and that they're gonna let it go to a jury.
You think she's going to rule that it's not ambiguous, though? Because that was the other half of this argument by defense counsel, that it's so ambiguous, and when it is, you have to rule in favor of the defendant.
I think that he made a wonderful persuasive argument, but at the end of the day, I think it comes down to the fact that the statute says do not leave. It says remain.
See, and that's why this might be a great case for jury nullification, which you're not allowed to do, but might want to do, because you both are saying accurately, read the statute.
Right.
The statute says remain, and even though there are a whole bunch of different scenarios where it just doesn't make sense to remain, you've already done your job. That's going to be an argument that you might have to make in front of 12 people, because if the 12 people are reading it like you two people are, they're going to say the same thing.
Yeah.
And then he's
He's out of
guilty.
it. Yeah. Well, we're going to switch gears a little bit. We're going to take you back